Hello everyone, Tim Tooth here. This is our agenda for this presentation. Hello everyone, Charles here. Last week we have observed a very enjoyable presentation from Team 4 for the criminal matters. We have already seen there are some special duties to both prosecutors and defense lawyers. And now let's take a look at the civil litigation. There are some similar ethical duties, but due to the difference of the nature of the civil matters, there are many different special ethical rules to regulate the lawyer's conduct in this area. First, in the civil litigation, it's all the same. The lawyers are still dancing with the chains, and the chains are kind of heavy. They not only owe the duty to their clients, but also owe the duty to the court, their opponents, administration of justice, and even to their supervising employees. One interesting thing in civil litigation, the common law and uniform rules gave the lawyers ways to escape from their liabilities. Look at the red circle of the retainer in the slide. If they can run out of that, they are free of trouble. Or they can run into the green circle of the advocate's immunity. If the court is satisfied that they are within the advocate's immunity, they can also run away from their liabilities. Unfortunately, not everyone can be that lucky all the time. As Shakespeare tells us, the that touch pitch will be defiled. In plain English, you can't touch something dirty without getting your hands dirty. The lawyers in the civil litigation are involved in very complex issues. There are a lot of times they are facing the difficulties of ethical choices. If only upon one time you think of taking some risks and believe you can run away successfully, be careful. My colleague will tell you later the disciplinary section could be very harsh, and the civil liabilities could also be big. Think twice before you leap, and remember the rich also cry. In civil litigation, if a lawyer is charged with incompetence or lack of care, it has to be established that the lawyer owes the duty of care and they breach that. In the contract law, a breach could be simply established if the lawyer does not comply with the terms of the retainer. In negligence, the retainer determines the scope of duty of care, and the complainant must show breach of duty and causation. Lawyer is also a professional and risky job, as the CLA 50 gives the professionals exceptions to get rid of liabilities incurred in the negligence. In civil litigation, the uniform rules and common law also give the lawyers ways to get rid of trouble by using the retainer to confine their scope of duty of care. As Solicitor Rule 2.2 stipulates, the common law helps to identify the solicitor's unsatisfactory professional conduct and professional misconduct. In Hawkins, the solicitor-client relationship may give rise to the duty of care to take positive steps to prevent economic loss in the particular cases. In Rogers, the general principle is that lawyers are expected to exercise reasonable care and skill in providing legal service. In Hayden case, the standard can vary depending on the lawyer's professional level. In civil litigation, the lawyers are not financially independent. Think about that. You are financially dependent on your client. If your client wants you to do something unethical, what would you do? For example, your client lied in the court. You know it. You owe the duty of loyalty to your client. Well, you also owe the duty to the court, to the administration of justice. Would you blow the whistle? You may think that you are the breadwinner in your family. You may think of your daughter's ballet class, your son's new laptop, and even the threat from your client. Before we dive into analysis of the facts scenarios, please bear these questions in mind. My colleague will give you all your options and consequences. You may make your own choice then. So, what is your choice in civil litigation? You want to be the hired gun or the wise counselor to your clients? What kind of a lawyer do you want to be in civil litigation? Will you always prioritize your client's interests beyond other duties? Do you think adversarial is a good choice in civil litigation? If you like to be your client's hired gun, will you worry a little bit about the discovery of your smoking gun someday? Do you really think you will always be the chosen one who's never be caught? Be careful, there are always eagle eyes, like my favorite man, Conan. We will show you two facts scenarios with non-issues in civil litigation. One is about an individual client, the other one is about a corporate client. The background of the first case is that the company FaceNote collects its customers' text message through the smartphone apps without their consent. The company knows that their system was hacked and some of their customers' personal information was leaked. Felix is a middle school student. He is FaceNote's customer. Felix had a crush on his classmate Jenny and texted a lot of sensitive messages to her. Then the information was leaked by FaceNote to the school forum. Classmates laughed at Felix. He got severe depression and attempted to commit suicide. Felix's parents sued FaceNote. So there are 6 issues arising thereafter. My colleague will explain to you one by one. Hongting will present you the first 3 issues. Then Xingchen will present you the last 3 issues for Felix.
The first issue is regarding instructing FaceNote to destroy the evidence. Is that wrong to be loyal to your client? First of all, lawyers own an undivided duty of loyalty to their clients. According to Solicitor Rule 7, a solicitor must provide advice to assist the client and make informed choices. Absolutely, it is right to be loyal to the client. Additionally, in this case, the firm's partner is the first solicitor. He instructed you to advise FaceNote deleting the information. According to the Solicitor Rules 4.1 and 9.1, the solicitor acts in client's interests and has duty of confidentiality. Besides, the solicitor has duty to the administration of justice. In this case, deleting the information belongs to dishonest and disreputable conduct. Based on Solicitor Rules 5.1, the solicitor should be a fit and proper person. For you, you have the same duty to client, which is similar to the firm's partner. Besides, according to Solicitor Rules 4.1, you need to avoid any compromise to their integrity and professional independence and comply with these rules and the law. Moreover, as a solicitor, you should comply with forensic judgment based on Solicitor Rule 17.1. Considering the civility, you should be honest and courteous in all dealings in any matter. The second issue is who is to blame for not disclosing the fact FaceNote deleted the data. In this case, the barrister Trump instructed you not to disclose the fact that FaceNote deletes the data during the litigation. For the barrister Trump, he should act in client's best interests based on the Barrister Rules 35. Moreover, he has extended duty beyond the clients from the Barrister Rules 4. According to the Barrister Rules 23, Trump has the overriding duty to the court. He should not mislead the court in Barrister Rules 24. However, Trump selected not to disclose the truth to the court. In fact, he should take all necessary steps to remedy from the Barrister Rules 25. According to Barrister Rules 49 and 50, Trump has duty to the opponent as well. He should take all necessary steps to correct any statements that mislead the opponent. As a barrister, Trump has a paramount duty to the administration of justice based on Barrister Rules 4. According to the Barrister Rules 8, Trump should disclose the fact that FaceNote delays the data rather than engaging in the dishonest conduct to diminish public confidence. I need to emphasize that the solicitor has a duty to the court and the opponent, which is different from the analysis I mentioned before, and this part is similar to issue 4. My partner Xingchen will analyze it further. You may argue that the barrister should blame for not disclosing the fact rather than the solicitor because it is the barrister that instructed the solicitor not to disclose the fact. However, Judge Kirby in Boland stated that the solicitor must exercise independent judgment and reject the barrister's advice if the solicitor considers that the barrister's advice is obviously wrong. In this case, the solicitor obviously makes a decision that not to disclose the fact, which is independent determination. Therefore, both barrister and the solicitor should blame for not disclosing the fact face note deleted the data. The third issue is, what duty did you breach when you applied to adjourn? This issue is related to abuse of court process and administrative justice. The lawyer applied for adjourning for 3 times solely to win the time to transfer and delay the data. This aim is obviously destroying the justice based on the Civil Procedure Act, Section 56. Besides, according to the Solicitor Rules 21, the solicitor should be responsible for use of court process and privilege. The solicitor applies to adjourn to gain some collateral advantage for the client, which has breached the rules. In this case, face note needs enough time to transfer and delay the data. If face note receives enough time, it is unfair for the plaintiff. However, the lawyer takes advantage of adjourn to help the company, which is surely destroying the administrative justice. Therefore, the lawyer breached the duty to the court.
The issue 4 is, as a lawyer, you chose to keep silent to your client's fixed testimony. Did you breach any duty? You may argue that, as a lawyer of adversary advocate, your job is to help your client gain the most interest, no matter using what approach, and you totally don't care about ethics or justice. However, you have in fact breached the rule by failing to correct the false representation. Based on Section 20 of Solicitors' Rules, as a solicitor, if you know your client has lied in a material particular to the court, you must advise the client that the court should be informed of the lie and request authority so to inform the court and refuse to take any further part in the case unless the client authorizes the solicitor to inform the court of the lie. In addition, you have a duty to the court as a lawyer. Instead of a hired gun, lawyer's competence requires you to behave independently and honestly. When lawyers' duty to the court conflicts with their duty to their clients, duty to the court always prevails. According to Section 3, a solicitor's duty to the court and the administration of justice is paramount and prevails to any other duty. And Section 5 says, a solicitor must not engage in a conduct which demonstrates that the solicitor is not a fit and proper person to practice law. That is to say, even though the solicitor has a duty to his client, the duty to the court will prevail it. Thus, the solicitor has breached his duty to the court as he helped his client to lie to the court. The next issue is, you know that a solicitor of your firm has privately transferred an amount from the trust account to the office account, which evidently breaks the rule, and the firm partner Taylor is so worried about taking the vicarious liability and asks you whether there is any remedy. Vicarious liability means that lawyers can be vicariously liable for their employees, and this conduct can attract disciplinary proceedings. Based on Brown's case, you will find that Taylor's worry is correct, because as a partner in charge of solicitors in your firm, Taylor has a supervisory duty to her employees, and failing to perform this duty will constitute a professional misconduct. Also, based on Section 37, Taylor must exercise reasonable supervision over the legal services of the solicitors and all other employees in the firm. And according to the outcome in Brown's case, he was only reprimanded because prior to the hearing of the matter, Brown gave an undertaking that he would cease practicing and pay the commission's costs. You could suggest Taylor to do the same thing. The last issue in scenario 1 is whether Trump will be sued because of his failing to object to the inadmissible evidence submitted to the court. The answer is, it is highly likely that Trump will be protected from civil suits because of advocate immunity. Australian law has long recognized a doctrine which protects lawyers, both solicitors and barristers, from being sued by their clients for negligence in respect of work performed in court. So, it is particularly important to distinguish between in-court work and out-of-court work. Following the decision in January, the intimate connection test suggests outside court work, which leads to a decision affecting the conduct of the case in the court, would constitute in-court work. Generally speaking, negligence related to work in court includes negligence in cross-examination, failure to object to evidence at trial, failure to advise a client that their evidence was inadmissible, etc. And out-of-court work usually includes mediations and settlement conferences. Since these actions are usually confidential and without prejudice, they will not affect the conduct of the case in court. In the present case, what Trump did was exactly an in-court work. Therefore, he is entitled to be immune.
Then my colleague Dora would present you some issues arising from a corporate client.
Now let's move to the second fact scenario, which is centered on the corporate internal policy. So another partner from the corporate section of your firm, John, who is the lead legal advisor to FaceNote the client in most of its internal corporate matters. So we'll walk through three issues under this fact scenario. The first one was that John had advised the client to store all its data in an unsecured cloud hosted in an Eastern Europe country so that no authority could track down the data. However, this ultimately led to the leakage of the user's private messages. Secondly, John had followed the client instruction and had prepared its internal data retention policy so that all the data was stored overseas on the assumption that it cannot be subpoenaed in Australia. And the purpose is really to defend the client's case if it is accused of making commercial use of the user's data. And the last issue was really a question for us as lawyers. So later on, it came to your knowledge that there were actually a number of correspondence between John and the Chief Information Officer of the client, which evidenced that there was instruction regarding the internal data retention policy and the real purpose behind it. So what would you do? There are two main duties that John had breached by advising the client to use an unsecured cloud. The first is a duty of competence under Solicitor's Conduct Rule 4.1.3, and the other is a duty of care under the Civil Liability Act. Also, the standard of professional service was defined in the case law Hayden and NRMA, in which the court said the standards can vary according to a lawyer's professed level of expertise. So in this case, it is difficult to argue that John had acted in a manner that would be accepted by other lawyers. And also, given that he is a very senior partner in the corporate section of the law firm, it's hard to argue that his legal advice or service has met his professed level of expertise. In the next issue, John has acted as the hired guns and followed closely on the client's instruction to prepare the data retention policy. The hired guns legal advisors are very similar to the type of adversarial lawyers. These are the lawyers who take advantage of the forms and letter of the law rather than the spirit or intent, so as to maximize the client's narrowly defined interests. On the other end of the spectrum, there's actually option to become wise counselors. Wise counselors are lawyers who advise corporate clients in a more independent way, and also are lawyers who mediate between the private interests of the corporation and the regulatory interests of the state. By acting as the hired guns, John has also breached the duty of independence of lawyer, as well as his duty to the court and administration of justice. The last issue was really a question for all the fellow students. In the case where John told you not to disclose any of the correspondence between himself and the client, what would you do? How would you voice your value?
Firstly, you can talk about the legal ramification. John could be found professional misconduct if he chooses to intervene in the court process under Uniform Law Section 297.2. There was also case law McCabe, where the lawyers were found professional misconduct in a very similar situation. There was also risk to the principles of the firm under the Uniform Law Section 34. The counter-argument was that we can't afford to lose a big client as face note. However, you can draw the attention to the partners that by doing this, it could raise questions with other big corporate clients as to the capability and the culture the law firm represents.
In recent years, it's been found that there is an increasing adversarial trend in the civil litigation. It could be mitigated by elevating the awareness of the civility to the lawyers and building the culture in the law firms to encourage the lawyers to obey the professional conduct rules. Where you want to go, who you want to become, it's all up to you. But before you decide to hide the smoking gun, please be aware of the sword holding in the hand of the God of justice. We don't give you the answer, we just show you your options. Hope you enjoy the presentation. Thanks.